We've been through several Scottish eviction cases this year, and the first thing many landlords misunderstand is what a notice to leave actually does. It begins the formal process. It does not necessarily recover your property. That distinction matters because some landlords believe that once the date is written on that notice arrives, the tenancy is finished. The tenant must leave and the landlord can simply take the keys back. But unfortunately, this isn't that straightforward. If the tenant leaves voluntarily, the process may end there. But if they remain in the property, a private landlord will normally need to apply to the First-tier Tribunal of Scotland for an eviction order. You cannot simply change the locks, remove their possessions, or decide that the notice itself gives you permission to take the property back. And this is where the time, expense, and frustration can really start to build. Before I go any further, this is based on our practical experience of dealing with several eviction processes this year. I am not a solicitor, and the correct action will depend on the tenancy, the eviction ground, and the circumstances of the individual case. Landlords dealing with an active eviction should take appropriate legal advice rather than relying on a general video. But there are some practical lessons from our experience that every Scottish landlord should understand. Most landlords think an eviction begins when the notice to leave is served. In reality, the work that determines the outcome starts much earlier. It starts with when the tenancy is set up. It starts with the tenancy agreement, the condition record, the deposit documentation, and the information given to the tenant. It continues through the rent records, inspections, repair reports, messages, emails, and notes of every important conversation, especially when they are verbal, on the phone or in person. If the rent begins falling behind, you need an accurate breakdown showing what was due, what was paid, and exactly how the outstanding balance has been calculated. If there are problems with the condition of the property or the tenant's behaviour, you need factual evidence rather than just vague recollections. A landlord saying this has been going on for months is not nearly as useful as a dated record showing what happened, when it happened, how the tenant was contacted, and what attempts were made to resolve any given situation. That does not mean you should treat every tenancy as a future legal dispute. Most tenancies will never reach that point. It simply means that professional record keeping matters from the beginning, because trying to recreate 6 or 12 months worth of evidence after the relationship has broken down is extremely difficult. Trust me, we've had to do that in a few cases that we've arbitrated over. The next important point is a Scottish landlord needs an appropriate eviction ground. You cannot simply decide that you would prefer the property back. With private residential tenancy, the reason for ending the tenancy must fall within one or more of the recognised eviction grounds. That might relate to rent arrears, the landlord intended to sell, the landlord intended to move back into the property, a serious breach of the tenancy, or another applicable ground. But the facts and the evidence need to support the ground being used. It is not simply a case of selecting whichever grounds appears likely to produce the quickest result. The tribunal will consider the circumstances and decide whether the legal requirements have been met and whether granting the eviction itself is reasonable. One incorrect date can set an eviction back significantly. And we know that from experience rather than theory. We've had an application rejected because of timing around the paperwork. That did not mean the underlying reason for seeking possession had disappeared. It simply meant that the procedural requirements had not been met correctly. And part of the process had to be started again, unfortunately. That's frustrating for the agent, us, and it's also frustrating for the landlord, who may already be losing rent, paying a mortgage, and waiting to regain control of their property again. So it's very important the dates matter, the paperworks matter, the relevant notice period matters, how the notice is delivered. We've been caught out with that before as well. That matters. The date is treated as having been received can matter. The eviction grounds very much so matter. The point at which the application is submitted matters. One small error at the beginning can create a much larger delay at the other end. That is why I would strongly discourage landlords from downloading a document, changing a few details, and then serving it without first checking that it is the correct form and the dates and grounds have been handled properly. The date on a notice to leave is not necessarily the date you get your property back. It is the point after which, as the next stage may become available if the tenant has not left. If the tenant stays beyond the notice period, the landlord then has to apply or can apply to the First-tier Tribunal for Scotland's Housing and Property Chamber. The tribunal does not simply rubber stamp the landlord's request. An application must be submitted with the required documents and a lot of supporting evidence. Both sides may have an opportunity to explain their position. The tribunal will consider whether the relevant eviction ground applies and whether eviction is reasonable in the circumstances. The process may involve written submissions, a case management discussion, or a hearing, depending on the case. And the landlord must continue to follow the proper process while all of that takes place. One of the most expensive things a landlord can do is wait too long after a tenancy begins to deteriorate. Now that doesn't mean serving formal notice after one late payment or treating every communication problem as an eviction case. Eviction should not be the automatic first response. Where the rent arrears are involved, landlords have responsibilities to provide clear information, direct tenants towards advice, and make reasonable efforts to agree a repayment arrangement. Sometimes a missed payment is temporary. Sometimes communication and an affordable plan can recover the tenancy and the missed rent. But waiting without taking any structured action is different from trying to resolve the problem. If rent is being missed, establish an accurate balance and keep regular records. Contact the tenant, record the response, provide the required information, review whether an arrangement is realistic. Get advice early. The longer the situation is allowed to drift without proper records or decisions, the more difficult it can become to untangle later. An eviction order, a payment order, and actually recovering the money are three very different things. An eviction order relates to recovering possession of the property. A payment order can confirm that money is owed and order the tenant to pay it. But an order requiring payment does not guarantee that that money will arrive immediately or that it will even be recovered in full. Further enforcement action may sometimes be required. So a landlord can successfully recover the property and still be owed a substantial amount in unpaid rent. That is a very difficult reality. The legal process can establish that the landlord is entitled to possession or money, but it cannot guarantee that the landlord will be put back into exactly the financial position they would have been if the tenancy has gone smoothly. Even when an eviction goes in the landlord's favour, the landlord can still finish the process significantly out of pocket. There may be months of unpaid rent. There may be damage or clearance work when a possession is recovered. There may be legal or professional fees to cover. There may be a period when the property just cannot be relet. If an order has to be formally enforced, sheriff officers may need to be instructed, which carries a separate cost. A locksmith may also need to be available if access cannot otherwise be obtained. It's very usual for sheriff officers to turn up with a locksmith on the day. We have been involved in coordinating that final stage, speaking with sheriff officers, preparing for access and arranging for the possibility that locks might need to be forced. It is a long way from simply sending a tenant a letter and asking them to leave. And it can be very stressful for everyone involved. The tenant may be facing the loss of their home. The landlord may be facing serious financial pressure. The agent may be trying to manage communication, evidence, and the property while staying within the formal legal process. That's why I don't think eviction content should be framed as landlords defeating tenants or tenants defeating landlords. We're basically providing homes for people, and as the landlords, they're trying to provide an extra income for themselves. The purpose of this process is to reach a lawful decision where the tenancy can no longer continue. Good property management cannot guarantee that you will never face an eviction, but it can determine how prepared you are when one happens. No letting agent can honestly promise that every tenant will pay on time, look after the property perfectly, and remain there without difficulty. Referencing reduce risks, it doesn't eliminate it. Inspections reduce risk, but they do not eliminate it. Good communication reduces risk, it does not eliminate. What good management should provide is early identification, accurate records, consistent communication, and clear escalation processes. When something begins to go wrong, the landlord should not be discovering that nobody knows the accurate arrears figure, that important conversations were not recorded, or that months have passed without any meaningful response. The landlords who struggle most during an eviction are often the ones who discover too late that their records are incomplete. So if you're self-managing, keep proper rent statement. Keep the tenancy documents together. Confirm important conversations in writing. Even if you're the type that likes to make a call or turn up at the property and have a chat, follow through with an email or a text, just agreeing what you've discussed. Don't exaggerate or use emotional language in your notes or correspondence. Record what actually happened. If rent is missed, address it early and follow the required pre-action steps. If you believe an eviction ground may apply, get advice before serving anything. And never assume that the first notice you find online will be suitable for your particular tenancy. This paperwork has changed over many years and it's still lingering about in the web, and it depends on your search term, so be careful there. The main lesson from the eviction cases we've handled this year is not that landlords should be frightened of renting out property. The lesson is that eviction is a formal process and that preparation matters. A notice to leave may start the visible part of the process, but the landlord's position has been shaped by everything that happened before it. How the tenancy was established, how problems were handled, and what evidence was retained. Acting early does not always mean evicting early. Sometimes it means communicating, agreeing a plan, and preventing the tenancy from reaching that point. But where the tenancy cannot be recovered, early advice and accurate records can prevent an already difficult situation from becoming even more expensive. If you have a tenancy that's beginning to cause you concern, or you're unsure whether your current management and records would stand up to scrutiny, you're welcome to have an initial conversation with us. We cannot promise a particular legal outcome, and we are not a replacement for a solicitor. But we can look at the management position, help you understand what information you currently have, and identify where appropriate professional advice that may be needed. I'm Brian from Be Listed, and this is the Landlord's Desk. Thank you for watching.